Hello, everyone, and welcome to InvenTank, the show for inventors where I am joined by a special guest host or two each week to help answer all of your burning invention questions. I'm your host, Lisa Lloyd, and we're streaming live today on LinkedIn, Facebook, and YouTube, or you may be catching our replay on your favorite podcasting platform. Today, we're very fortunate to have not one, but two special guests, Randy Landreneau and Paul Morinville. Randy is president and Paul is founder of US Inventor, an organization dedicated to restoring inventors' lost rights in Washington, D.C. And today they're going to help us all, yes, including me, learn more about those rights and what we can do to preserve them. As a reminder, you can drop your questions in the comments at any time throughout our program, and we'll dive into those in just a moment. But for now, welcome, Paul and Randy. Thank you so much for being here today.
Thank you.
It's great to be here.
Absolutely. I have a confession to make. I started inventing 30 years ago. And of course, I was the president of the UIA at 25 years old. So I didn't know what the hell I was doing. And we were formed to, in part, lobby for the rights of the independent inventor. And I always had a problem with it. And I think that internal mechanism for me was, you know what, I can't control what I can't control. I want to control everything that I can. So I'm going to just stay in my lane over here and invent as often as I can. And if some asshole comes along and steals it, I'm just going to try and move on to the next good idea instead of getting wrapped up in the pain and suffering that goes along with any kind of litigious scenario. And I did get sucked into one lawsuit at one point, and it was enough to confirm that I never really wanted to be there again. So I have avoided, consciously made choices to avoid playing around with the rights for the independent inventor. And not that it's not important, I'll just leave it to the other folks. And I haven't even really educated myself. So I'm personally very excited to learn more about what you're doing to help all of us, and even maybe what I can do to get more involved in helping the next generation of inventors so that they don't have to struggle with that same question of should I be over here or should I be over here in the future. So why don't we just start by giving everyone, our audience, a little bit of a background on each of you, if you don't mind. Paul, we'll start with you, just so people understand kind of who we're learning from today.
So I used to work for Dell Computer when I was young. I had hair back then. I invented some stuff at Dell. Dell said, go start a company, we'll fund it. So I left Dell in April 3rd, 2000, right as the bubble
they
was
would call that a
collapsing.
spin out, right?
Well, in a way, it was a spin out. What they were doing is they were a hardware company. What I developed was enterprise. It was in enterprise software. So it didn't relate to their business. They said, we'll just fund it. So, but that all collapsed when the bubble collapsed. And long story short, in about 10 years later, I started working with Purdue University to commercialize my inventions. I had investors and spent a lot of money. Everything that the vendors put in, I spent. And in 2013, the effects of the America Invents Act, the Patent Trial and Appeal Board, became clear. And my investors came and said, sorry, guy, your patent's no good anymore. We're not investing anymore. So I don't know what you did the last time the government killed your company, but I hopped in my truck and drove to Washington and started raising hell. I go into a Senate office. There was what they called the Innovation Act, which would have made it worse. They were going to screw investors even more. Had passed the House 325 to 91. So I went into the Senate. I'd walk into a Senate office and I'd say, hey, I got to tell you about what just happened to me from the America Invents Act and now what this Innovation Act is going to do. And the first question they had is, who are you with? And I said, well, I'm not with anyone. You guys just killed my company. I'm not even with my company anymore.
Wow.
But they said, go to your state. And that at the time was Indiana, and talk to them. We don't talk to people from out of state. So I went geometrically around the Senate office buildings and went to every single office. And I got into 4 or 5 of them. And that was about it. And I thought, this isn't going to work. I got to be with somebody. So I went home, got usinventor.org, threw up a website, faked 2,500 members. And I went back the next week and they asked, who are you with? And I handed my business card and I said, well, I'm with US Inventor.
That sounds much more impressive. Oh, wow.
Then this guy from Florida started arguing with me, telling me I was wrong. And I'm never wrong. But that guy was Randy. And Randy, I convinced to come up and join me. And Randy, why don't you tell your story from here?
Yeah, so my background, like a lot of us inventors. I mean, I don't have an engineering background, probably should have, like Paul doesn't have the background of his invention, but it's kind of like you come up with things as you go, your life changes. And my background is finance. Well, at some point in my life, I realized, gee, I'm coming up with some good ideas. I can invent. And I started looking into it and reading books about it and getting fired up about this great America. This was started in 1790. This is why America, it's our patent system and our ability to own what we have and what we've created. This was revolutionary in America when it started. No other country had that. And so I actually became the president of the Tampa Bay Inventors Council, which is a local nonprofit. And of course, if you were at UIA, you're kind of connected to all these groups. And at some point, I found out that big corporations were trying to screw up our patent system because they didn't like competition from startups. And this is the problem. And I totally understand your point of you want to be an inventor, you don't want to be involved in litigation, right? You know what? When the system is working the way it should, these big companies think twice before they just steal stuff, because if you do get involved in litigation, they could lose big, right?
Right.
So what you want is really strong rights. It's kind of like as a country, if you're really strong, you don't get attacked, right?
Sure.
But anyway, I was involved with the Tampa Bay group, and I started finding out, in fact, from Inventors Digest magazine, of course, I'm sure you know all about that, about what was happening, and in fact, I was back, 11 years ago when they were getting ready to pass the America Invents Act. I started getting on the horn and calling all these people around the country and trying to get people to call their senators, call their reps and go against it. And I didn't know at the time that you can go to DC and fight in person and actually lobby, and you can. Well, it's a little tougher with the whole COVID thing, but in general, you can.
Right.
Anyway, we lost on that bill. We got crushed. That was the American Invents Act. We'll talk about it more. But then a couple years later, they're about to pass another bill, which was as bad or worse, and that was called the Innovation Act. They always name them something really nice, right?
Sounds nice.
And I started doing the same thing. I got on the phone and started calling all my contacts, and I found this guy in Indiana doing the same thing as me. He was out there online and saying, hey, this bill's going to be terrible, and called him up and started arguing with him because there was something about it. I can't remember. There was one particular element that he didn't think, he didn't think it was as bad as I did. And we argued, and I don't know, somehow we resolved it. And I went to DC with him, and that kind of started.
I wasn't wrong, but I was mistaken.
Yeah. What was the disagreement over?
I felt like, so there was a particular aspect of the bill that I thought was just the worst thing possible, and Paul wasn't so sure.
That was loser pay. So if you sued Google and lost, you would have to pay Google's legal expenses.
That's right.
And I thought, well, that means they'd have to pay mine. But I didn't consider the economies of scale that Randy considered, and their expenses could be $30 to $50 million. There's no way that you would ever be able to do that. And then they also, in that, not only because that would bankrupt me, the real reason that I was mistaken was that the debt, if you lose, pierces the corporate veil and goes to your investors. And that means an investor investing in a patent lawsuit has an unlimited liability. They may only put $1 million in, but they may be on the hook for 30 million, and then you would never get investment. So
interesting.
And it was, I got to tell you something. The thing that we didn't have in Washington, D.C. that we needed so much was a real voice. And when Paul and I went to the Senate, this thing blew through the House. It was about to blow through the Senate, because as your viewers, some of your viewers, if you're inventors, you're probably working on your stuff, and you might not, I didn't even know that you had to go through the House and the Senate to pass a bill, right? Well, I know more than I want to know about all this stuff now. but we went to the Senate, and one for one, all of these key staff members we met with in all these offices, they said, wow, I hadn't heard from anyone like you. I've only heard from big tech lobbyists. Yeah. And so they thought, and I thought it was a great bill, and we were about to vote for it. And it was only because we showed up that thing stalled. Now, it came back with the next Congress. It came back stronger than ever, with more money behind it than ever, with people that you can't imagine behind it who shouldn't have been, who drank the Kool-Aid, listened to the propaganda, whatever, sold by big tech, and accepted their money, of course. But in the end, we were a key part of stopping it. So this is a huge win, and this is how US Inventor began.
Wow. Okay. So,
and by the way, I want to say one quick thing, because as an inventor, it's like, oh God, I don't want to know about all the law stuff. My patent attorney will handle it, blah, blah, blah. Let me tell you. Oh, and the Constitution will protect me. Well, you know what? Your rights are in the Constitution, but that's not good enough, because they have passed laws that go against that. And in fact, I remember, Lisa, did you know Bob Rines?
Oh, yes. That's a long time ago.
So Bob Rines was, for your viewers here, he was a kind of a famous patent attorney and an inventor. He was actually in the Inventors Hall of Fame as well. Yeah. And he was a big deal. He was he and his wife
Joanne Hayes Rines was on the board of directors with me when I ran the UIA. So yeah, long time ago.
I think maybe they started the UIA.
They did. They were she was basically the lead, took the lead in that role. So yeah.
And he would go to DC. He was really our voice in DC. And he was just one guy, but man, he would pound on desks, and they all knew him, and they knew he knew what he was talking about. And he slowed down a lot of bad things, right? Yeah. And he stopped bad things, but mainly slowed the process down so they couldn't get us too bad. But then he died. And he wasn't there in 2011 when the American Invents Act got passed. And but the good news is now US Inventor is there, and we've got a serious presence. We have about 60,000 members, and we're everywhere, and they can't get away from us.
Good, right? We're flanking them from all sides.
Yeah.
All right. So I want to continue the conversation, and I also want to jump in and answer a question real quick from one of our listeners. But I do want to pop up on the screen here for those who might just be joining us. We're talking with Paul and Randy from US Inventor. If you'd like to go to usinventor.org, you can learn more about what your rights are, or what rights you may deserve and are not getting currently, as well as what you can do to get involved. If you do usinventor.org/resolution, it'll take you straight to the page. And that's what I really want to learn more about today, is this resolution. But before we dive into that, I did notice that Celeste, hello, Celeste, so glad to have you. She's joining us from South Africa. She would like to know, and I don't know the answer to this. I mean, I could guess, but do you happen to know I'll just pop it up on the screen. Why does it take so long to get a patent, given that the case, quote unquote, is straightforward? So even a simple patent.
Good question.
Let's just go for the hard one right up front.
you may not even get a peep from the patent office for like a year. Right. Like, hey, great.
Usually longer than that. You might not get one for a year and a half, or you may not get a first office action for 3 years. You can file and this I think is really bad, but they did it anyway. If you want to pay an extra $4,500 or whatever, you can get it evaluated in less than a year.
I think they call it like an accelerated.
It's expediting it. Yeah.
Yeah, that was for the little guys to get their patents faster. But the biggest user is Google, and so they're pumping all kinds of money in there, and that slows everything else down. So I think it's a sin for them to take so long. It's ridiculous, but it is what it is. I have patents in there that I filed in 2002, and I still don't have.
Wow, what category are they in, Paul?
They're 3600. They're in the category that competes with the core enabling technology of big tech. That's why I don't have my patents.
But see, that also gets us into a whole nother thing that we don't have time for here, which is, you know, for a lot of your viewers, you know, I gather that some of your viewers are brand new, some of them are kind of experienced. If you actually invent something that could absolutely change the world and that would really disrupt like the major, most powerful corporations in the world, you could face a whole different thing than normal, which is what Paul's patents have done.
Right. And that's actually was part of my thought process. I'm not changing the world. And by the time someone does knock this off, it's going to be after I've licensed it to a big company who's more threatening than I would be if I were going to market myself. And so it's not likely that it's less likely, we'll say, that a company would knock them off than it would be if I was going to market with the same product, because they know they have to defend it against that or enforce it or whatever against that other big company like Scunsy. So that gave me the peace of mind, I think, in many ways. But with this new law and the way things are going, especially with a less low tech world, which I believe is more what Josh has struggled with, correct?
Yeah, and see, in Josh's case, for your viewers, so Josh Malone invented Bunch of Balloons. That's that toy that allows you to fill like 40 water balloons at a time. And you talk about go viral. I mean, when I heard about it, I thought, yeah, it sounds pretty good, but I had no idea. It's unbelievable.
It's a weapon of mass destruction in the water balloon fight world.
Right. You make 100 a minute, you know. But so again, so we're low tech. Obviously, big tech doesn't care about water balloons, but what they've done to the system affects any patent that's really valuable. And any patent that's really valuable, there's going to be a big player or more than one in that industry. In Josh's case, it's Telebrands. Telebrands is the biggest as seen on TV company. And they bought one from his Kickstarter campaign and shot a commercial with it and flooded the market with his product. Didn't even talk to him. And one of the problems that you will face, though, with your viewpoint, just to tell you, you're saying, well, I'll license it and they'll have to deal with it. Well, at some point, the one who would license from you says, wait a minute, why should I license it?
Yeah.
In other words,
you can't defend a patent. Who cares?
Yeah. Which is why you need to have patent right. In other words, the ability to stop an infringer, a legal ability that has some real teeth in it, like we used to have 15 years ago, so that they don't play games like that, and they will license because even you without much money. I mean, I'm not saying you have no money.
No, I know. That's fine. Say it. Without much money, I have nothing.
But the point is, when the system is workable, you fight these fights on contingency.
Yeah.
And that's where I know a guy that did this 30 years ago. He had a high-tech shock absorber and showed it to a car company. They said, we're not interested. Then they took it, they copied it, and he found an attorney who did it on contingency. That's where the attorney shares in the winnings, but you don't have to pay him much up front. And he was poor. He didn't have any money. In the end, he won a couple $1 million because they were guilty. So the system can work, but it has to be fair. And right now, the problem we have is that one of the key problems, and there are actually three different ones, but one of the key ones we talk about a lot is from that bill, the American Invents Act, where they created an administrative court to handle what were supposed to be just certain patent issues. Prior to that, all of these battles would take place in a real court with a jury, with a lifetime appointed judge, with a lot of due process. But now there's this administrative court where almost all these battles end up, and it's very unfair, and there's no jury, and there's no real judge. In fact, there are these administrative judges that sometimes have unbelievable conflicts of interest, like they used to work for the company that's trying to invalidate your patent sometimes. And they have an 84% kill rate, right? 84% of the time, they invalidate the patent in question. Now, of course, this is only the really valuable patents, right? This is only patents that, like in Josh's case, big company wants to take it, he tries to stop them, they end up taking him there. So you could have something that's under the radar that you're making money off of, not getting rich off of, but surviving or doing well, and maybe it stays under the radar and never gets attacked. But if you ever get attacked, you might come up with something truly really valuable, and you never know. I think we all could have come up with a bunch of balloons if we had thought about it.
The value of a patent is the real value of a patent, it's like a deed to your house. That protects your house and the land it's on, and it's transferable. A bank can look at that deed and you can collateralize your deed to accept a mortgage. And then if you don't pay it, the bank takes the deed, sells the house, and gets their money back. A patent is exactly the same thing on an invention. So an investor is going to look at that patent and wonder, can I get my investment back if your startup fails? So, I'm going to take the risk on that. And if you fail because you get knocked off, if you fail because you're a bad manager, if you fail for whatever reason, the investor gets the patent. And then can you license the patent to get that investment back? Just like a bank looks at, can I sell the house to get the mortgage money back? Mm-hmm. The problem with that is, the value of a mortgage, of a deed and a mortgage, is that it's very stable law. Property values are, property rights are property rights. It's gonna work. And if that were to fall apart, there would be no mortgages and nobody would buy houses. Nobody would improve houses. With patents, it does the same thing. If you can't enforce it later, nobody invests. So there are three things. Randy talked about the Patent Trial and Appeal Board and how that's invalidating 84%. But there's two other things that are equally as bad. One of those is because of a case called eBay versus Merck Exchange, if you sue an infringer, you have to be able to prove that you have a product on the market and the distribution capacity of that infringer in order to get an injunction. In other words, stop them from selling it. And the problem,
that's after you win your case. You win your case.
That's after you win. Yeah.
But still, you have to be able to prove, they call it public interest, to be able to stop them. It's crazy.
That converted a personal property right into a public right there. That one decision by the Supreme Court in 2006. And what it does then, if you're a big company and you're looking at a little guy, you're thinking, well, if I steal this and I massively commercialize it, he'll never be able to get a distribution. He'll never be able to build a product because I've already taken the market and nobody's going to invest in it. And then what happens is they take it. And then you go sue them and you win, you can't get an injunction. That means that you can't determine how valuable the patent is at the earliest stages, because if you can't relate it to a market, you have to relate it to whatever an English major in a robe, some courthouse in the future, is going to determine its value. And there's no way to project that. So what it did is it wiped out, that single thing wiped out funding for startups. And then the PTAB, with its 84% kill rate, you have to get to that point to get an injunction. You can't get past the PTAB. But there's one third thing. Section 101 in the patent code is the door into the patent system. And what it says is any, and that's the biggest word in this sentence, it's only 3 letters, any product, process, composition of matter, or machine is eligible to be patented. Well, in 2014, the Supreme Court, then also legislating, because that's what they do, created an exception to the word any, and that's called an abstract idea. So anything except an abstract idea is eligible to be patented. Then they didn't define what an abstract idea is. And if you break down any patent, at some point it's an abstract idea. So 67%, of the, if you sue somebody, go to court, and they first challenge it as an abstract idea, 67% of those are invalidated as an abstract idea. So you have the first problem is the PTAB. You got an 84% kill rate there. If you survive, then you got abstract idea, 67% kill rate there. And then you can't get an injunction. You have to rely on an English major in a robe who's never marketed a product to determine its value. So now, if you're going to invest in a startup, I think you're pretty stupid. And that's what's happening.
But I want to say something before. Don't, to your viewers, don't leave yet. Don't get totally depressed and leave, because there's some good news here. There's honestly, gee, Paul, come on.
You know what? I was just going to go quit my job and just like.
Well, it's always been good advice. Don't quit your day job anyway, right?
Anyway.
until you're making serious money on your invention. But,
right.
Here's the deal. Number one, yeah, we got all these problems, and if you have something that the big guys want to take, they have all these things now they can use to take. Then it's an impossible set of obstacles for a little guy. But here's the good news. One, we're making serious headway in getting a bill passed that will change all that. That'll address all these issues. That will turn us back to about where we were 15 years ago. And this is a bill that we have to get all of our representatives, U.S. representatives and senators backing. It's called the Restoring America's Leadership and Innovation Act. Restoring America's Leadership and Innovation Act, H.R. 5874. It's the bill of Thomas Massie. He's a representative from Kentucky. He went to MIT, is an inventor, had 30 patents, had a very successful startup based on those patents and funding based on those patents. He's the guy in Congress that knows the most. And a lot of people are listening to him. We have a lot of support for it. I think we have now 21 co-sponsors. But the way it works in Congress, you have to have a House bill and you have to have a Senate bill, like a companion bill. And, so we're working it. We're hitting it from a lot of angles. But I would say this. Everybody listening to this, you should call your U.S. representative and your senators and say, this matters. I'm your constituent. I want you to support, if they're a representative, tell them you want them to co-sponsor H.R. 5874. That's Thomas Massie's bill. And if they're a senator, tell them you want them to sponsor a companion bill to H.R. 5874. And this, by the way, this is the system we have now. The broken nature of our patent system is why big tech has so little competition, because they can simply destroy any competitor that has patented technology that they want. By the way, that was their plan in getting our system changed so that they could stop their competition. It's also why China is threatening to take the lead on key future technologies like quantum computing and artificial intelligence and all that stuff. Because we've hamstrung our real innovators, and we've created a system where China actually uses that. Chinese companies use that same administrative court to invalidate the patents of Americans legally. It's crazy. The
U.S. PTAB to invalidate them.
Yeah.
So okay,
it's HR 5874.
5874. Let me edit that. I apologize. 5874.
And the good news is we have a serious presence in DC now. Now look, we're not like big tech. I mean, they got all the money in the world and they have armies of lobbyists, but we're there. They can't avoid us, and we show up where they don't want us. And like when in the Judiciary Committee hearing on the new patent director that Biden appointed, we actually got 5 different senators to oppose her. That's never happened in history.
Wow.
So not that it stopped her, but the point is we're there. They know we're there, and we're moving the needle. So
there are 3 things that drive Washington, and only 3 things. If you understand these 3 things, you make it happen in Washington. Everything is driven by money, media, and votes. Big tech has control of the media.
Yeah.
Yeah, maybe that too. But But the money, media, and votes. Big tech has control of media. They have all the money. What we have and we have access to are the votes back home, and the people back home who call their congressmen, who call this thing out as the fraud it is that's destroying American startups and inventors. And that's where most of our focus is. Randy's is inside Washington. Mine is outside Washington because I cuss too much to be inside Washington. And Randy's much prettier face.
Oh, stop it now, boys. All right. So I'm going to go to our audience real quick for a question here, gentlemen. Help me answer this. Gabriel would like to know, if a big company wants to buy your patent, but you only want to license it, what's usually their reaction to that? Is it common for them to walk away and end up copying your idea, even though it's patented, and they can out-lawyer you?
Yeah, I don't know how common that is, but I would say in the current environment, I mean, look, we expect to win this battle, but again, that's it's not a guaranteed thing. If you get a pretty good offer, you might want to take it. You get anyway. What do you think, Paul?
It depends on the value, the potential value of the invention. If you've got an invention that's gonna bring in billions of dollars, they're just gonna steal it from you. They're not gonna talk to you. They're not gonna try to.
But no one really knows. Everyone hopes. That's why they invent it. They hope it's going to be that $1 billion product, but no one really knows in foresight. So
if they think it's going, if they think it will be that, they will steal it. But if your invention is going to bring enough, a large enough market that you can make a living on, or that, if you keep it small, this is the sin of all this. If it's small, they probably will license it because they don't want the bad publicity. They don't want the lawsuit. They don't want any of that stuff. If it's big, they steal it.
I think that's an important point, Paul. Thank you for saying that. And for all of our listeners today, most companies are not doing what the Googles and these examples they're talking about. Most companies, I've been doing this for 30 years, and it's never once happened to me. So most companies, this is not the case, but it only takes one, frankly, and it will consistently, in fact, where you see this more often, which is exactly what you were just saying, I think, Paul, when it gets into the economics, if it's big enough or they believe it can be big enough, then there is enough companies out there that might do that. So having these laws in place, and that's, again, so that goes back to me why I stayed out of it. I just going to focus on inventing and working with the best possible companies. And if someone steals it, I'll move on to the next idea. However, I do see it happening more, and companies are getting more brazen even about it. And what I'd like to know from you, and what I hope to help our audience understand, in addition to myself today, is in layman's terms, let's start with what's broken, and then I'd like to understand what they thought they were doing to fix it when they did it, because I have a hard time believing that it was strictly someone greasing someone's palms that got us to where we are. I think that there were some people with good intentions. They would even argue their good intentions when they created these laws, right? So I'd like to know what's broken, and maybe the flip side of why they thought that would work.
Well, I'll say this. I think the vast majority of our lawmakers were hoodwinked. They didn't have bad intentions. The vast majority of them, maybe a few did. Yeah. Well, there are definitely a couple for sure, I think.
Sure. There's always bad apples without bad actors, right?
But you got to realize, one of the best statements ever, this kind of tells it all. Bill Gates was interviewed in 1998. And the interviewer, who's kind of a famous guy, asked him, this is back when Microsoft was at their peak. He was asked, what is it that worries you the most in business? And he thought Bill Gates would say something about a competitor like Oracle Software. He immediately said, somebody in a garage inventing something I haven't thought of. Because that is the threat. That is the threat to the big guys. If that person in a garage who's thinking outside the box comes up with something really good and can patent it and protect it, that could be a real competitor. And that's what they're worried about. And these corporate attorneys have worked overtime to figure out how to limit future competition, because they're trying to grow that company and make it bigger and bigger and bigger. And honestly, there were very few real issues that needed to be addressed. I mean, there's always some frivolous litigation, right, in America. Attorneys are attorneys.
Let's go into that real quick. So in every technology boom since the beginning of the United States with our patent system, there's been a boom of inventions. In the 1800s, farm implements they boomed in farm implements. Farmers would invent stuff, different plow blades or levers or whatever. Alice Chalmers, I think, went around and bought up all those patents, as many as they could, and ended up being who they are. The sewing machine, lock had a lock stitch where the needle goes through, grabs the thread, and comes back up. But his carriage went in a circle. And when he sewed, it bunched up the fabric. So Singer said, okay, well, I'm going to draw the fabric straight through. And Singer created a sewing machine that's doesn't bunch the thing. It actually became the first global consumer product ever. It was an enormous market. So everybody jumps in. And now all of the knobs, dials, and switches inside of a sewing machine were all invented in the 10 or 15 years before the Civil War. Then they all sued each other, and they ended up locking up the entire sewing machine market. Nobody could sell anything. So what they did is, nobody patents for nothing. And all of this is coming to a point. Nobody patents for nothing. They patent for profit, right? You're doing this for money. You're not doing it for a line on your resume.
It's not a hobby, it's a business.
Right. So they created what they called the sewing machine combine, and everybody put their patents in there, and they all decided based on whose patent was most valuable. So the Howes was the most valuable, how they're going to divide the money afterwards. And anybody who sold a sewing machine put $25 in there to divide it out. So the market fixes itself. Now, at that time, there were judges in the 1800s talking about patent sharks, these people who buy up patents. And they were trying to pass legislation to gut the patent system because people were, rich people were buying up patents just to sue the companies that are producing these products for the American economy. And that's a terrible sin. They called them patent sharks. Well, luckily, we had a government that believed in a constitution and did not disrupt it. But the same argument was brought up in the tech revolution. There are literally millions and millions of inventions. You create the internet and all the things you can do with it, everybody's inventing. So patents went up everywhere, even including Google, who patented the search algorithm. And there were lots and lots of patent cases. And they called them patent trolls. And patent trolls run around buying up patents and suing the providers of those products. And that's a drag on the economy. Some said $80 billion in fake reporting paid for by Google, with law professors like Mark Lemley and some people in Boston University. And they created this imaginary patent troll. It's a cartoon character. And in order to stop out cartoon characters, we need to change patent law. So that's what they did. They stomped out. But let me bring you back to what a patent troll is. Who is a rich guy with a patent who doesn't have a product? If I'm an inventor and all I have is a patent, and I come to you and you're an investor, and you invest in my company, big tech steals my stuff, runs me out of business, just like the deed. Now you own my patent. You didn't invent it. You're some rich guy, and now you're going to go sue the companies that ran me out of business. You are a patent troll. So by reclassifying this in such an enormously dishonest way, they have destroyed the patent system. And that was the argument. It's frivolous litigation, and they bought it hook, line, and sinker.
Yeah. Wow. I hope you all followed that train of thought, because the logic is simple in hindsight. But it's still fascinating to me that the best of intentions were, I think, in place originally. Obviously, we don't want people to invent and keep it off the market. That doesn't help the economy, which is the whole point of the patent system, right? Is to bolster the economy and encourage innovation. Well, if you're going to innovate and just hold it back from the rest of the world, then it should be taken away from you. I agree with that. Now, if you can't, you don't have the means, there are different reasons for that. So we should probably support helping those people more, which is, I think, what we do with our clubs. But the reverse, there's two sides to every coin. The flip side is you get unscrupulous people, which happens in every single industry, who figure out how to abuse the power and manipulate the system to capitalize on it. And it just goes down the hill from there. Would you say that's right?
Yeah.
No? You're welcome to disagree with me. Just because it's my show doesn't mean I have to be right. That was for you, Paul.
But just to add to what Paul said, there's a woman named Zarina Khan who has done all this research over time. And what she found, and she had in her book, I think she even graphically shows it, that at all these different points in history, you have some new technology that comes out that people get patents on, that starts, like Paul was saying, in her case, she showed the telegraph and the telephone and the locomotive and the automobile and all the way up to cell phones, right? And at every point where that new industry comes out in the early years, there are a lot of lawsuits, and you have big companies that are infringing patents getting sued, and those big companies and all those different examples go to DC, and they have actually gone to Washington DC to try to weaken our patent system. And even the Wright brothers, there were companies that didn't want to have to pay the Wright brothers any money. And it's like, why should we have to pay these bicycle mechanics something? Well, those were the inventors. Yeah, you got to pay them because they own this. And so there is this viewpoint from the big corporation. And actually, since about 1850, they've been trying to weaken our patent system. Luckily, our politicians held firm until about 15 years ago. But anyway, so we're fighting hard to bring it back, and we got a lot of support now. We have a lot of we have momentum, and the thing that any of your viewers and any this isn't just for inventors. This is for anybody who cares about America. Tell your representatives and your senators to get behind this bill, HR 5874. This is for America. If we don't restore these rights, one, we're no longer going to lead the world in innovation. That's the one thing that we can do better. That we can't compete on cost of labor. We can compete on innovation though, but not if we don't have a patent system. And how are we going to stay ahead of China if we're not innovating ahead of them? So this is really important.
Super important. Okay, so quick question from Mark here in our audience. What recommendation, and hi Mark, by the way, is one of our students. What recommendation would you give to inventors to safeguard their provisional to patented inventions?
So provisional patents are not made public. You have 12 months to turn them into a utility application, which then is made public in 18 months.
Yep.
So I think that provisional patent applications are very, very valuable. You take that and you have a perceived ownership. You can go to license it. A lot of times the companies will just license it and take the provisional and then file it. If you've got the vast majority, 95% of all inventions are going to be okay to protect with a patent. It's those that are highly valuable that are a problem. I wouldn't not file a provisional.
But I want to say one thing too to all of your listeners, because you might be thinking, should I go small? Should I go big? If you think about Josh Malone, he invented a really simple thing that ended up being hugely valuable. And I say this, don't hold back. If it goes big and you end up in these fights, well, you know what? You know who we are. You know US Inventor now, and we will help you. You can be part of the effort to fix the system. And I'm going to tell you something, nothing plays better in DC than an actual small inventor who's getting screwed by the big guys. In fact, we have a young woman who's been to DC now at least once with us. Her name is Molly Metz. She's a 5-time world champion speed jump roper. Did you know that? Did you know it was a sport? No.
Must have missed that one.
She's in better shape than any of us will ever be. But anyway, but she invented.
I could get my belly bouncing that way.
My glasses bounce on my face.
But she invented a new way to connect the rope to the handles and got a patent on it and was selling, for speed jump roping. And it's like the industry standard now. And a big company in the industry called Rogue Sports took it and invalidated a patent at the PTAB. And but it's terrible. Yet she is, her story is helping us get this bill passed. So you could help us. But secondly, the fact that you know us means that if you do get attacked, we have some resources and some knowledge, especially with some of our attorneys we work with, who can help you. And don't hold back. I say go for it. But I will say this as well. If you can keep it as a trade secret, in other words, if it's something that people can't figure out, keep it as a trade secret. Absolutely.
And more companies are licensing without patents now for all of these reasons.
Really?
Which is interesting. Yeah, the toy industry, they recognize the fact that it is a seasonal type business. The shelf life is fairly short, 3-5 years on most toys now, especially with tech. So since it becomes obsolete so fast, they don't see the real power in having any intellectual property on it, as long as they get to market fast enough with their big brands. So we're seeing that trend in toys. Mm-hmm. We're seeing it in dog toys, also dog type products, leashes, those sort of things. It's interesting. It is trending in that direction though, for the very reasons that they just don't see the economics in the business sense for it.
Those companies that are trying to license from a lot of inventors have a lot of reputational risk if they rip off inventors.
That's right.
They do it too many times. Nobody brings them inventions, and their business model collapses. So there's reasons for them to treat you fairly.
Exactly. And in fact, I was just talking with someone who's a toy broker, and we were having this very conversation. And I said, how can an inventor feel safe or sure that they're not going to get knocked off if they're pitching a product to a company without a patent? That's the scariest thing I can imagine for an inventor who's already really paranoid. You know?
Yeah. Somebody out here has an experience where one of these companies that are trying to attract inventions from inventors screws you, please let us know, because we'll help with the reputational damage.
Yeah, exactly. And what she said is actually in that business, it's even though it's very fragmented, it's still a very small industry, a very close knit industry, and everybody talks about each other. So if someone screws someone else, that just becomes fuel for their fire to put down their competitor, so to speak. So they really do care about their reputations, not just as a favor, but they'll use it against each other. So it's a backdoor way of working, but it works. Okay, so I see another, oh no, actually, I addressed that question. Gosh, we're coming up on the hour already. We've only got about 14 minutes left, folks, 13 minutes. So if you have any last minute questions, make sure you drop them, because there is a time delay. And I want to remind our listeners too, that if you would like more information, you can also go to, let me pop that back up here. Whoops, usinventor.org/resolution to learn more about the HR 5874 bill, and call your senators, congressmen, and get support, or potentially even get them to co-sponsor that. So Mr. Massey's bill, let's talk about this for a moment. Can you tell me, I know IPR, the letters, the acronym, IPR, PTAB, and I believe there's one other major facet of this bill that you're hoping to see impact some change, correct?
There are a few things, but go ahead, Paul.
Tell me what those are.
It does three things. It does more than three things, but the three main things it does, the most important things, is it restores injunctive relief upon a finding of infringement. So you sue somebody and they're found to infringe, the court by default enjoins them from selling anything more, stops them. Now you have a willing buyer and a willing seller in a fair market to negotiate a price. So that fixes that. It eliminates completely the Patent Trial and Appeal Board, that non-judicial corrupt institution that's wiping out 84% of our patents. And then it also eliminates, under Section 101, the abstract idea exception to the word any and stops that whole mess. But those three things are the most important things to fix in the patent system, so that we get back on track when we take over China again in development of new technologies.
Yeah. Well, there are a bunch of other things in the bill that are also pretty interesting. Like, for instance, as it stands now, if you apply for a patent, unless you decide you're only going to apply in America and opt out of the publication of your patent, they will publish it after 18 months. Like, let's say you're planning to leave it open to be able to file in other countries or whatever. Your patent application gets published in 18 months, even though you don't have a patent yet. Well, that's not okay. So you may have no patent for another couple of years, and everybody gets to see exactly what you patented. But
can't you just file the 18-month rule?
Well, you can opt out of it if you're only going to file in America.
At the time. Oh, okay. So if I do,
they don't always do that though. They published mine anyway.
Wow, really?
Yeah, they did. They didn't care.
Even though you submitted
I submitted it to be a U.S. only, keep it quiet, don't publish it patent, and they published it anyway.
Paul made the mistake of inventing something that would absolutely disrupt the most powerful corporations in the world.
What were you thinking?
I'm not going to do it again, I'll tell you that.
Or keep it to yourself. Maybe you just do it smarter, right?
I'm going fishing. So
I have a couple questions. I have a couple questions about the things you just mentioned. First of all, PTAB, getting rid of that process. And instead, I assume this means that we go back to just traditional courts and Juries. Okay. So I've spoken with a lot of attorneys over the years who absolutely hate jury trials with regard to intellectual property specifically, because juries don't understand it and it's so complicated. And then you get a judge who doesn't get it or understand it. And it makes it very difficult to argue to all of the ignorant people in the room. So how do you overcome those challenges when we go back to that system?
I disagree with that whole jury thing completely.
Okay.
You've got and I'll have an article out next week, I think, on this very subject, hopefully on IP Watchdog. Juries.
IPWatchdog.com is where they can find this article.
Yeah, IPWatchdog.com. I'm an author there, and I write patent related and small inventor related stuff.
Awesome.
So juries understand. It might be completely new to them, but if you have two opposing sides who are trying to explain it to them, and they boil it down to the simplest possible way for the jury to understand, and the jury has to decide which one is right. That's what juries do well. And everything a jury's looking at, it, whether it's a murder case or a patent, is new to them. Juries are there to keep an honest decision, and the fact that that they say that they can't do it is, I think, insulting and arrogant on the
and
part
like I said, as lawyers that have made that argument to me, not
the only ones that make that argument are the big tech companies that don't want jury trials, because juries make fair decisions. That's the only one who makes that argument.
Yeah, and I will tell you this: I mean, look, these attorneys, there are people who complain about whatever, and so yeah, they're going to complain perhaps. But if these attorneys you're talking to, if they're trying to defend a patent holder, an inventor, in a case, if they've been through a PTAB trial, they will love juries instead. So,
right.
Yeah.
More stuff makes sense.
There's a recent case in Florida with Parkervision where the jury consisted of, I think it was 6 people. All of them had 4-year degrees, and 3 of them had master level degrees. Juries are not dumb podunk. Pauls.
And I don't think that was I don't think they intended. It's just that it's intellectual property law in general is extremely complex in some ways. And whether the attorney is up to the task of educating them in the short amount of time that they have to really get them up to speed to make a valuable and, I guess, educated judgment on the whole thing is what they're arguing. But I'm with you. I think you get the right.
As you're saying that, I'm kind of thinking, Paul, maybe you can tell me, am I onto something here or not? The guys who have the greatest advantage in making it complex as hell is big tech, is the guys on the wrong side of the issue.
Right. That's what I was thinking.
On our side, it's really simple.
Right.
So you would think they would want to go to a jury.
Yeah, on our side, it's simple. It's like, here it is, and they took it.
Right.
Big tech doesn't want to go to a jury, because juries are people. They're your peers. Mm-hmm. There are people who are from your probably in the area where you live. They understand that. Sure. They see a little guy who's come up with a big idea, and then some big corporation who's coming in and trying to confuse them on it.
Sure.
And they find for the little guy.
And another thing too, Lisa, this is interesting. So one of the things that your viewers know, any of your viewers who have applied for a patent, is that to get a patent granted, the invention has to be non-obvious. That means to someone skilled in the art, it wouldn't be too easy to come up with. But one of the arguments, and if you get a patent, the patent examiner is saying, hey, it's non-obvious. But one of the things in life that kind of proves it's non-obvious is you come out with it, no one's thought of it for years, you come out with it, and suddenly it's a huge success, right? Now, what they try to argue, that the opposing side tries to argue as well, it's actually obvious. But no, the proof is that it's not obvious because...
Or they would have been doing it.
Yeah.
If it makes money, they would have already been doing it.
Yeah.
Anyway. Well, I love debates. Okay, so Wendy has a quick question here. We'll try and get through a couple more before we wrap up. After the show, could you send out 2 to 3 talking points in favor of HR 5874? It might also be helpful to send a link to a page that helps people determine. Can we, I would encourage everyone, assume you have a newsletter or something on your website that people can subscribe to get the information that you're
Hey,
talking
by the
about.
way, well, actually, if Wendy and for everybody else, if you sign our inventor rights resolution, let's go to that link that Lisa showed. You'll actually be on our email letter. You'll periodically get emails from us telling you what we're doing and how it's going and all that stuff. Everything you're wanting, you'll get from that.
Okay, and that's for our listeners who can't see it on the screen, usinventor.org/resolution. Okay, I'll leave that up on the screen. Thanks, Wendy, for your question. Gabriel, I just got my design patent issued in Canada. Is there something I should know before making my next move in that regard? I'm not sure which regard. Yeah, Gabriel, I'm not sure which regard, but the best, I don't think we've spoken in the past. I'm going to go ahead and pop up my website. You're welcome to book a free strategy call with me. I think that's probably the best way for me to answer that question. The more I understand about where you're at and what you're trying to do in the category and some other moving parts, the better and more strategic my advice can be for you. So feel free to book a free call. And this goes for any of our listeners. Just go to theinventionaccelerator.com and you'll see my calendar there. So you can find a time that works best for you. All right. So in the last few minutes here, we've got about 4 minutes left, gentlemen, and we don't have to finish right on. It's not like radio, but about 4 minutes here. What final thoughts would you like to leave us with beyond going to the website in just what we should be doing right now actively in our preserving our own rights, or even considering as we're filing our own patents?
Well, I think that in this patent fight, this is a fight on whether or not America stays ahead of the world in innovation. And it is highly dependent on if we fix this the way it was, the way it always has been in the United States for the first 200 years. Mm-hmm. But I don't think on the other side of that, on inventions, the vast majority of inventions will be protected. You'll be okay. And you should continue to invent and file, patents. But if you have a big idea, you have a really big thing and you run into problems, or if any of your the companies you're talking to steal it from you, let us know. We'll help you.
Yeah.
How do you know if you have everybody thinks they have a big idea. That's why they're doing it, right? How do you know if you have a really big idea and should probably be investing in using an attorney and not writing your own patent, for example?
That's a tough one.
It's a guess on the market. How well do you know the market? How well do you believe people are going to do it? And then you might find somebody, one way to do that is find somebody, an investor who's willing to agree with you and help you pay the money to file the regular patent application.
Well, one thing I'd highly recommend, though, even if you've got the money to hire good attorneys and all that, you should actually get Patent It Yourself by David Pressman.
Is that still relevant today?
Yeah. Yep.
Wow.
Yeah, Patent It Yourself by David Pressman.
I bought it when I was getting started.
The basic information and like as far as your patent, getting your attorney, look, it's easy to get a very narrow patent, but you want a very broad one, and you kind of have to fight with the patent office to get it as broad. They're going to try to narrow it where you want it broader. Broader simply means it covers your invention more fully, so someone can't even get close to it without infringing it. And you need to know this stuff. You cannot leave that up to your attorney. But I want my final statement. I want you to really realize how important innovation and this whole, what we're talking about has been to America. When America was founded, the world was run by aristocracies. If you were a friend of the king, you might get granted an exclusive right to, like, say, run a port. And that was even called a patent back then. But nobody cared about the little guy. The common person didn't matter to the aristocrats. And our founders said, hey, if you in America, you invent something that's never been done before, no matter who you are, you can own it. That changed the course of mankind. And interestingly, this was 1790, was the Patent Act of 1790. Inventors, you think about this, women didn't have a lot of rights back then, but inventors were described as he, she, or they. How about that? So women had all the rights of men when it came to patents and copyright. And even further, the first Black owner of a patent was 1821. He was Thomas Jennings. He invented the first version of dry cleaning. Wow. And did quite well with it and used his wealth to help get relatives out of slavery and to help the abolitionist movement. Of course, a patent, unfortunately, his patent today would probably be invalidated. That's why we got to bring our system back to the intent of it The intent of our patent system is all so perfect and so great. And it's what kind of helped build America. And it's why we can't let a handful of corporations destroy it. We got to bring it back. So that's my statement.
It's awesome. My worst fear is that no matter how much we try and come at this from every angle and insulate ourselves from bad actors, they will always be there and find a way to perpetuate the problem and abuse the system and take advantage of the weak or the ignorant or the broke. So it's just, unfortunately, that is the human condition that we face in this world, right? But anything that we can do to insulate, I'm on board for. I have a whole new love, passion, respect for what you have done. And I know that you have put in your own money, your own time, countless amounts of hours doing this for not just us, the independent inventor, but our country. I've never been an activist, but I think you've sold me on the little bit of investment that I can make to make potentially a very big difference. So thank you so much for coming on the program and explaining all of that.
Yeah, thanks for the opportunity.
Yeah, thank you. I'm going to definitely be resharing this video. I hope that you will share this also with your audience, because you've done such an amazing job of explaining this. For anybody who doesn't understand this, this will be available. You can come back and check it out in the same way that you got here today. Just click on the link or share it with your friends. Please help us get the word out. The more that you do, even just those little acts can make a big difference in the overall influence that ultimately we collectively have with the United States and making a difference for inventors. So thank you, everybody, for being here. Thank you, Paul.
Thank you.
Thank you, Randy.
Thank
I
you.
hope you'll come back again. Keep us posted, please, on what's going on. If there's something new to talk about, let's do this again. I would love to have you. It was fun.
Super. Thanks.
Awesome. Thanks, y'all. Have a great rest of